Hello, everyone. Welcome to the ARC National Center on Criminal Justice and Disability webinar. My name is Ashley Brompton, and I'm the Criminal Justice Fellow at NCCJD. Before we begin our presentation, I'd like to cover a few basics, especially for those of you who are new to WebEx. Participants are in a listen-only mode. If you need help during the presentation, you can post questions in the chat box on the side of your screen, and we would be more than happy to help you. At the end of the session, there will be time for questions. Throughout the presentation, you can either post questions in the Q&A section or in the chat box. If you don't want your name shared with your question, please type private before your question. You can also email questions to nccjdinfo@thearc.org. If we don't have time to get to your question during the presentation, we'll follow up with you afterward. This webinar is being recorded and will be posted on our website along with the PowerPoint slides and a transcript in about a week. We have one final request. A short survey will pop up after you close WebEx. Please take 5 minutes to complete it. This survey will help ensure that you are satisfied with this and future webinars and provide valuable feedback to NCCJD and our presenters. This webinar is funded by the United States Department of Justice, Bureau of Justice Assistance. Thank you for your participation. Thank you to our presenters for taking the time to be here with us today. I would like to now introduce you to the new incoming Criminal Justice Fellow, Ariel Sims. Ariel completed her Juris Doctor degree at Harvard Law School and has a Bachelor of Arts degrees in Psychology and French from Saginaw Valley State University. Prior to law school, Ariel spent 2 years working as a mental health counselor at an inpatient psychiatric unit of a hospital. After that experience, she decided to become a disability and human rights advocate, especially on behalf of those living with mental disabilities. Throughout her time in law school, Ariel worked on disability rights issues both in the United States and abroad, including healthcare policy, human rights, and criminal justice reform. I'm now going to turn it over to Ariel to begin the presentation.
Thanks so much, Ashley. Before we hear from our distinguished panelists, I just wanted to take a couple of minutes to discuss two terms that are often confused in the criminal justice context: capacity and competency. Capacity is a much broader term and generally describes people's ability to understand their actions and consequences of those actions at a particular moment in time. It is also a very fluid concept and not only varies from person to person, but also from decision to decision. For example, it could be said that someone has capacity to work, but not the capacity to manage his or her own financial affairs. On the other hand, competency is a purely legal concept that asks the question whether someone involved in the criminal justice system has the capacity to understand what is happening at various points in the legal process. For instance, there is a general test of competency to stand trial, which Bob Fleischner will be speaking about in just a moment, but there are also competency tests to plead guilty or to waive one's Miranda rights. For those of you who are more visual, you can see in this simple diagram that the concept of competency is encompassed within the broader concept of capacity. And with that brief introduction, I'd like to introduce our first speaker. So Bob Fleischner is an attorney at the Center for Public Representation, a national public interest law firm with offices in Northampton, Massachusetts, and Washington, D.C. He has represented people with disabilities since 1973, when he graduated from Boston College Law School. He has litigated and argued appeals in prison and juvenile justice reform cases, guardianships, fair housing, civil commitment, right to treatment, and right to community services cases. Bob has served on the faculties of Western New England University Law School and Smith College School for Social Work. He has also published a book on guardianship and numerous articles and book chapters about disability law. So with that, I'm going to turn it over to you, Bob, and you can go ahead and turn on your video and unmute yourself and tell us a little bit more.
Okay, thank you very much. There we go. I'm going to talk about some of the distinctions and differences in the way that competency to stand trial concepts affect people with mental illness and people with developmental and intellectual disabilities. In the United States, we do not put defendants at risk of their life or liberty if they don't understand essentially what's happening to them and what is at risk for them in the course of the criminal case and a trial. The constitutional test developed by the Supreme Court for competence to stand trial is whether the defendant has a sufficient present ability to consult with a lawyer with a reasonable degree of rational understanding and a rational and factual understanding of the proceedings, and whether the defendant, whether he or she can assist his or her counsel in the preparation and carrying out of the defense to the charges. Not surprisingly, most defendants who are found not competent to stand trial have a mental disability, either intellectual disability or mental illness. Incompetent defendants, then, if a person is found incompetent to stand trial, they can't be tried, at least for as long as they remain incompetent. When they become competent, they can be tried. So they can be tried later if they're found competent. And that realization of competency, either the achievement of competency or the restoration of competency, has to happen in what the Supreme Court has called a reasonable time. In the meantime, the defendant, for a reasonable time, may be committed to a facility, and often is committed to a facility, for the purpose of retaining competence or achieving competence if they've never been competent. In some states, in order for an incompetent defendant to be committed to a facility for restoration, the defendant also has to meet the standards for civil commitment. That, depending on state law, those standards usually are that the person has a mental illness or an intellectual disability in some states and is dangerous to himself or others if not placed in an institution. The fundamental issue, a fundamental and difficult issue, is, as I said, how long a person can be involuntarily detained for treatment or for education to attain and achieve competence to stand trial. Now, the question was first addressed comprehensively by the Supreme Court in a 1972 case, in a case called Jackson versus Indiana. Mr. Jackson was illiterate, he was deaf, and he was unable to speak. Experts who examined him told the trial judge that the chances that Mr. Jackson would ever be competent to stand trial were virtually non-existent. Nevertheless, following the dictates of Indiana state law at the time, the trial court committed him to an institution until he became, in the words of the Indiana statute, sane enough to be tried. The Supreme Court reasoned that the nature and duration of Mr. Jackson's commitment had to bear some relationship, a reasonable relationship, to the purpose of the commitment. So in other words, what was happening during the commitment had to bear some relationship to what the purpose of the commitment was. And the Supreme Court said that since Mr. Jackson could not be brought to competency, that he couldn't be held any longer than was reasonably necessary to determine that there was a substantial possibility or a substantial probability that he will attain competency in the foreseeable future. The court then held that it's permissible to commit an individual to an incompetent defendant to a facility for restoration of competency, but the term of the confinement had to be reasonable to determine whether the person could retain competency in the foreseeable future. Since 1972, courts and legislatures have struggled to figure out just what reasonable means, the reasonable time is, and just what the foreseeable future is. As an example, in Massachusetts, the way that we've dealt with it here is that after an incompetent to stand trial defendant has been institutionalized for 2/3 of the maximum term that she could be sentenced to if she were committed of the most serious crime for which she was charged. In other words, if she was sentenced for the most serious crime she was charged with, she became eligible for parole, which is after 2/3 of the sentence. The charges then in Massachusetts have to be dropped, and the individual has to be released. or civilly committed if the individual meets the civil commitment standards. Now, so how frequently does all of this happen? It's very hard, as it often is in court-based things in the United States, to come up with reliable statistics. But according to the literature, there are probably about 12,000 defendants a year who are found incompetent to stand trial. Somewhere between 6 and 16% of the defendants who are found incompetent to stand trial are people with intellectual disabilities. Of those defendants who are referred for an evaluation, so the court or a lawyer has some question about their competency, about 12.5% to 36% of the defendants with intellectual disabilities are determined incompetent to stand trial, while about 45 to 65% of defendants with mental illness are determined to be incompetent, a substantially higher figure. From available data, from a review of the case law, from anecdotal reports, from the literature, it seems less likely then that a defendant with an intellectual disability will be found incompetent to stand trial as compared to a defendant with a mental illness. Defendants with intellectual disabilities are also less likely to attain competence and to stand trial at a later date. That second fact is less surprising to me than the first one. But there may be some reasons for this, and some possible explanations may be that defendants with intellectual disabilities are less likely to have been competent in the past as compared to defendants with mental illness. The strategies to attain competency for defendants with intellectual disabilities are probably often more complex than the ones to restore competency for defendants with mental illness. For some defendants, for example, with mental illness, medication and psychotherapy may help. For defendants with intellectual disabilities, on the other hand, the treatment may have to involve education, vocational training and therapy, speech therapy, and so on. Because of the relative complexity of these methods and the staff intensity necessary for them, facilities that receive people who are incompetent to stand trial may be less well equipped to serve them. So where do people go when they're found incompetent to stand trial? State statutes and practices often set out the types of facilities to which incompetent to stand trial defendants may be sent. These types of facilities can vary quite widely. Perhaps state psychiatric hospitals are the most common and are used even inappropriately for defendants with intellectual disabilities in some states. Some states have constructed and operate special ID/DD facilities for court-involved defendants who are not competent to stand trial or have been found not guilty by reason of intellectual disability or mental defect or whatever the standard is. These facilities are usually very secure and can look and often be operated as if they were prisons or jails. Some incompetent to stand trial defendants may be held in jail either for restoration or more commonly for extended periods while they await a bed in a more appropriate facility, and you're going to hear more about that later. Massachusetts, unlike probably any other state, places some incompetent to stand trial defendants, including some with intellectual disabilities, in a prison, forensic prison, which is euphemistically known as the Bridgewater State Hospital. Finally, most states allow for, but do not very often use, community-based programs for restoration. This alternative is the least restrictive alternative and the one that responds to what is allegedly a bed shortage crisis for incompetent to stand trial defendants. But because the individuals have pending criminal charges, it's often difficult to convince courts and communities that they should be cared for or treated in a community-based program. Now, achieving competency. The likelihood that an individual with an intellectual disability will achieve competence is low, and the length of time that the person will spend institutionalized is longer as compared to individuals who are found incompetent because of mental illness. Only about 1/3 to 1/2 of defendants with intellectual disabilities who are determined to be incompetent to stand trial are eventually found to be competent. Notwithstanding these differences among mentally ill defendants with mental illness and defendants with intellectual disabilities, all of these defendants with mental disabilities share some common issues that are of concern and that are systemic. Except with the most, perhaps with the most disabled defendants, clinical predictions of whether a defendant will become competent are often not reliable. Sometimes it's little better than a informed clinical guess, and is dependent on lots of predictable factors. That's determining what the foreseeable future is and when a reasonable time has passed. Accordingly, courts' determinations of reasonable time may vary considerably, and as will determinations of what the foreseeable future is. Parenthetically, to this point, it's worth noting that in 2004, an analysis by Professor Michael Perlin showed that nearly one-half of the states, this is some 30-some years after the Jackson case, nearly half of the states had not implemented, enforced, or operationalized the requirements of Jackson, which Perlin correctly calls, I think, a failure that's unthinkable in any other area of constitutional law. The nature of the alleged crime may also impact clinical and court decision-making. Clinicians and courts are likely to weigh the seriousness of the offense and the seriousness of the likely punishment, either consciously or unconsciously, in making decisions about competency. The same considerations may enter, and probably do enter, into decisions to dismiss charges, to release the person with a disability from a facility or from secure confinement. And these things may be much more difficult depending on the charges and the available programs, including programs that the court and the community will consider secure. So, the conclusion from this, I think, is that for both defendants with intellectual disabilities and those with mental illness, the criminal justice system's competency processes are designed, although they're designed more for defendants with mental illness, there are substantial problems for both. The serious shortcomings faced by defendants with mental illness are exacerbated for defendants with intellectual disabilities. And you'll hear more about that as the webinar goes on. So thank you.
All right, thank you so much, Bob. Our next presenter is Claudia Center. Claudia Center is a senior staff attorney with the ACLU Foundation's Disability Rights Program. She litigates cases that increase civil rights and civil liberties for persons with disabilities and is actively involved in legislative, amicus, and appellate work. Ms. Center argued before the U.S. Supreme Court in U.S. Airways Incorporated versus Barnett, a case that clarified the scope of reasonable accommodations for employees with disabilities. She spearheaded the 2000 amendments to California's Fair Employment and Housing Act that confirmed the Act's broad protections for persons with disabilities. Prior to joining the ACLU, Ms. Center worked at the Legal Aid Society Employment Law Center for 19 years and at the National Abortion and Reproductive Rights Action League for 2 years. She obtained her BA in Government and African Studies from Wesleyan University in 1987 and her JD from Bolt Hall at the University of California in 1992. She was a recipient of the Echoing Green Fellowship and of the Women's Law and Public Policy Fellowship. So with that, I'm going to turn it over to Claudia. Yes.
Thank you. Right.
1 second, Claudia. I got to get these privileges here. Sorry, give me 1 second here, Claudia. Apologies, everyone. We're having some slight technical difficulties. Give us just 1 moment. Okay, Claudia, go ahead and turn on your video. And it looks like I'm going to have to change your slides for you for the moment. So just let me know when you want to go to the next slide.
Okay. Is that good?
You're good, Claudia. You can go ahead.
Okay, great. So I'm going to talk a little bit today about the difference between guardianship and whether a person is incompetent to stand trial. And I'm also going to talk about what attorneys should think about when they're representing individuals who are under guardianship or conservatorship, as it's called in some states, and it's very common. So you can go ahead on the slides. Yeah. So guardianship and whether a person is incompetent to stand trial are two distinct assessments under state law. Often the laws themselves will use similar words, so it seems as though they're almost connected, but they're really two distinct assessments that are made for different purposes and in different contexts. So guardianship or conservatorship is really about whether somebody is unable to provide for their basic daily needs, even with supports, and whether someone's competent to stand trial is about whether they are able to understand the criminal proceedings set against them and whether they're able to assist in their defense. So the outcome of one assessment does not determine the outcome of the other assessment. So you can go forward on the slides up to one more. So when thinking about representing someone who is under guardianship or conservatorship, I think it's important to have a little bit of background on the guardianship system or the typical guardianship system in most states. So if you look at the language of the state laws that define guardianship, it seems as though it's a very narrow standard. It's often described as the least restrictive alternative. The judge is supposed to grant it with clear and convincing evidence. There's supposed to be a hearing. But in practice, there may not be that type of close scrutiny and evaluation in granting a guardianship. Guardianship might be granted because it's deemed to be in the individual's best interest, or a parent may seek a guardianship because they really need to manage the finances of the individual, but they are actually able to do everything else. A service provider may require guardianship, like a doctor may say, oh, I need guardianship to get consent to this medical procedure, or a service provider may say, we want guardianship, as part of our process for administering this service. And also guardianships may have existed for a really long time, so they may have been put in place many years earlier without a lot of substantive review over the years. So I think that it's important for an attorney to basically not make any assumptions based on the fact that a guardianship is in place. It doesn't mean that the individual can't communicate. It doesn't mean that they can't have an attorney-client relationship. It's something that obviously you have to take into consideration, but it's not a determinative fact on how that relationship will proceed. So next slide. So the rule of thumb basically is that you want to presume that the individual can be a client just like any other client. Now you may have to have reasonable modifications that I'm going to talk about in a minute. There may need to be different strategies for how that attorney-client relationship will proceed, but your basic rule of thumb is going to be to presume that there is competency to have the relationship. And so we're lucky in that the ABA model rules of professional responsibility really give some guidance. Rule 1.14 and the comment to that rule are really your go-to sources for any situation where you're not sure how to proceed. Now that doesn't mean that, next slide, that doesn't mean that there aren't going to be hard situations, or it's not that the rule is going to answer every question, but I think it's a very helpful guidance for all of us who represent individuals who have this legal status. So what Rule 1.14 says is that as far as reasonably possible, the attorney should maintain a normal, I know the word normal is funny, but it's in the rule, normal client-lawyer relationship with the client. So you want to assume that the client, when properly advised and assisted, is capable of making decisions about important matters, just like a client without a disability. You want to give that client attention and respect, and you want to communicate with the client, not just, communicate with the guardian or conservator. Next slide. It's important to know that strict confidentiality applies with an individual with diminished capacity. So that's Rule 1.6 in the model rules. But there is some important information in the comments to Rule 1.14 about situations where a family member or a supporter, where it might be appropriate to have them present during certain meetings. And that would be if the individual with the disability wants that person there, and if that person's presence is necessary to the legal representation. Now, there is some tension with cases in some jurisdictions that talk about third parties being present as extinguishing attorney-client privilege. But if you can show, kind of track the language of the comments to the rule, that the person wanted that individual there and that the supporter was necessary to the communication or the representation, I think that's an area where you could make a modification if it seemed as though it was the right thing to do. There's also an exception set out in the rule for when the attorney needs to make some limited disclosures for emergency situations to take protective action, which we're not going to get into too much here, but I just wanted to mention that there is that other area. Next slide. So with any individual with a disability that you're representing, particularly individuals with psychiatric disabilities or with intellectual disabilities, you may want to think about modifying your strategies to enhance the representation and to make sure the communication is effective. So, the biggest element under this category would be accessible communication. And lawyers tend to struggle with accessible communication. And, so the strategies that we adopt to communicate with our clients with mental disabilities can help with any client because it's good for any client. So using simple, accessible language, trying to avoid legalese, using short declarative sentences, try to take a legalese, take that word and try and break it down and use common words to describe what it means. Written materials like retainer agreements or other types of informational handouts, you'll want to develop plain language versions of these written materials. And some of the organizations represented in today's webinar have examples of these kinds of materials. Important information should be repeated, maybe stated in different words if it seems as though there might be an issue with communication. And there could be multiple formats might be appropriate for accessible.
Do you have a help so she's still going to be able to talk and stuff?
Accessible, so maybe like email or writing or orally, etc. Next slide. So this goes back to what I was talking about with Rule 1.14. that existing support networks can help with the representation. You know, if you follow the guidance of the comments to Rule 1.14 to try and support the individual during the attorney-client relationship, which, you know, is stressful and requires the individual to think about difficult and complex issues and make decisions. And finally, just flexibility and time. Accommodating the individual's needs, their abilities, their preferences, maybe meet with the individual at their home or in a comfortable environment, maybe have shorter meetings, maybe meet more frequently, or whatever it is that seems to be effective. So that's all pretty much common sense, but I think sometimes it's good to lay it out. And so that concludes my comments.
Thank you so much, Claudia. Sorry, we were still having a few technical difficulties here behind the scenes. We're hoping we have the situation corrected. So I would now like to turn things over to Robert Dinerstein. Robert Dinerstein is Professor of Law, Associate Dean for Experiential Education, including Director of the Clinical Program and Director of the Disability Rights Law Clinic at American University, Washington College of Law, where he has taught since 1983. Prior to coming to WCL, he was an attorney for 5 years at the Department of Justice, Civil Rights Division, Special Litigation Section. From 1994 to 2000, he served as a member of the President's Committee on Mental Retardation, later renamed the President's Committee on People with Intellectual Disabilities. Among his many publications, he is co-editor and co-author of A Guide to Consent, author of Guardianship and Its Alternatives in Adults with Down Syndrome, co-author of Lawyers and Clients, Critical Issues in Interviewing and Counseling, and author of Implementing Legal Capacity under Article 12 of the UN Convention on the Rights of Persons with Disabilities, The Difficult Road from Guardianship to Supported Decision-Making. He has an AB degree from Cornell University and a JD degree from Yale Law School. And so with that, I'll turn it over to you, Bob.
The issues we've been talking about. So first, what is supported decision-making? Supported decision-making could be defined in different ways, but one of the ways to think about it is a less restrictive alternative to guardianship. Guardianship itself has various levels of restrictiveness from limited to plenary, but before you even get to it, supported decision-making is an alternative to it. Its main characteristic and its way that it's distinct from guardianship is that somebody who is making use of supported decision-making retains his or her capacity and competency, both terms of which we've talked about so far. So it is a way to assist people rather than to supplant them, and that's really its critical element here. In my presentation, I'm going to be talking about not just how supported decision-making affects defendants, who we have been speaking about, but also witnesses and victims who are, of course, a kind of witness. And insofar as people are increasingly using supported decision-making, it is important that the criminal justice system be aware of how that might be used in particular contexts. Okay, so what is the definition of supported decision-making that we might use? I took a stab at it a few years ago, and I think this definition has held up pretty well. Supported decision-making can be defined as a series of relationships, practices, arrangements, and agreements of more or less formality and intensity designed to assist an individual with a disability to make and communicate to others decisions about the individual's life. And with more time, we could go into the different aspects or elements of that definition, but I think you get the idea. The idea is a way to help people, assist, support them in conducting their lives. Okay. Supported decision-making precedes the UN Convention on the Rights of Persons with Disabilities, which came into effect in 2008, but it got a very big boost from the convention, in particular from Article 12, which is an article on equal recognition before the law. Article 12 says that everybody, every individual has legal capacity and cannot lose that capacity. We've been talking here about what might be called mental capacity, and even in those cases where there's a questioning of it, people are able to retain as much capacity as they can and can be assisted to act, even if they do need assistance and can't act alone. Supported decision-making, as I said, got a boost from Article 12, but it actually is something that owes its origins to work in Canada, particularly British Columbia, which uses something called representation agreements. Bulgaria, Israel has a recent statute, South Australia, which is one of the states in Australia, and a number of other countries, Sweden and Norway being two others. In the United States, it is a relatively new concept and relatively underdeveloped as of yet. Right now, there's one statute that I'm aware of in Texas that's a broad general statute including supported decision-making as an alternative to guardianship. There's some statutes in D.C. that have used it as, that are pending or proposed statutes, which may adopt it but have not yet done so. In the courts, there have been cases by probate judges or surrogate judges, the Jenny Hatch case in Virginia, the Ross versus Hatch, and then two cases of several in New York, In re Damaris L. and In re Michelle M. And judges in these cases have concluded essentially that the proposed, in those cases where guardianship was proposed, supported decision-making was a less restrictive alternative to allow the person to achieve his or her ends without needing to lose his or her rights to make decisions. Most of the time when we talk about supported decision-making, we're actually talking about it in a civil context. So in guardianship, with respect to guardianship, I should say, and as a way to permit people with disabilities to be involved in all the kinds of decisions in their daily lives that you might expect people to have. Decisions about their education, about their finances, about their relationships, intimate and otherwise, about where they want to live, etc. But conceptually, there's really no reason not to apply supported decision-making to the criminal justice system. So let's look a little more specifically about how supported decision-making might work in that context. First of all, imagine we're dealing with somebody who is a victim of a crime. A supporter or support network, and I will use the two terms interchangeably, could assist the victim with understanding the nature of the crime that was committed and being able to communicate to the prosecutor and police important information about the crime. Could include who the perpetrator was, the circumstances of the crime, etc. For an individual with a disability who has difficulty communicating, having somebody in his or her network who can help essentially serve as a kind of interpreter could be a critical role, a critical thing to have available to him or her. That person also could be providing emotional support to the victim as he or she recounts the experience that the person has had with the alleged crime. But again, as with other aspects of supported decision-making, the victim retains his or her agency, retains his or her ability to choose whether to be assisted, and if so, in which ways. Interestingly enough, in the Article 16 of the Convention on the Rights of Persons with Disabilities, it provides that appropriate forms of support should be available for people with disabilities in the criminal justice system. And I should perhaps say, for those not up on their international law, the United States has signed the Convention on the Rights of Persons with Disabilities, but has not yet ratified it. There were two efforts to do so in the Obama administration. They were not successful. It could be brought up again. It certainly will not be before the next Congress. So right now, from a U.S. standpoint, the convention is something that is of interest, and it has been cited by some legal jurists and by commentators, but is not yet positive law in the United States. Okay, well, what about witnesses who, of course, may be victims or may simply be witnesses to a crime? Again, a lot of the same issues would apply. And in addition, if we think about people who are testifying, a supporter or support network could assist the person in interpreting his or her testimony to the judge or the jury, the trier of fact. This may seem a little odd to you. The fact of the matter is, if somebody communicates in unconventional ways, through a communication board or otherwise, it may need a kind of interpreter or somebody to communicate or to convey the context of what the testimony actually is. And that assistance could not only be in terms of communicating what the witness wishes to communicate, but into understanding the questions that the lawyers may pose either on direct or cross-examination. It is important to understand that if the individual does not have, is not competent, that is, cannot testify in a competent way in understanding the meaning of what he or she is testifying to and understand the meaning of an oath, then he or she would not be able to testify. But in my view, and there's no real court support for this yet, but in my view, as somebody who was competent with the assistance of his or her support network ought to be able to participate, including to testify. Now, defendants, of course, have all the same kinds of communication or potentially communication issues, and they have some additional concerns as well. One, of course, is they have constitutional rights to confront their accusers, to understand the nature of the charges against them. These rights underpin the reason why we don't try people who are not competent to stand trial. But a supporter or support network could assist the person in understanding the charges against him or her, and also in allowing the person to participate in his or her defense. And as Claudia said in the just preceding presentation, that person as supporter would not stand in the place of the individual, would not be somebody that you would communicate with solely and not talk to the defendant or your client, but rather could be somebody who could assist in that. And in fact, when we think about supported decision-making in this context, it looks a lot like the request for reasonable modifications or accommodations that we would ask in the court system. So in effect, the supporter or the person being supported brings his network or supporters to the court proceeding, but the court itself, the court system, may need to be providing accommodations to allow that person to participate and understand. And again, somewhat overlapping with what Claudia talked about, use of plain language and the possibility of presenting a witness who can explain behavior that might otherwise be difficult for the trier effect to understand could be a role that supporters or a support network could play for a defendant with a intellectual disability in particular. There's, as I said, not a lot of case law really in this area. It's very much on the cutting edge or leading edge of this of the issue of supported decision making. But there is an interesting case, a relatively recent civil case from Illinois, from Chicago. It's Reed versus State of Illinois. The citation is up here. It's from the Seventh Circuit. It's a 2015 decision, and it's written by Judge Posner of that court. And in this case, there was a pro se civil plaintiff, that is somebody who did not have a lawyer representing her, who had tardive dyskinesia. She brought a case, a personal injury case on her own, and asked the court for various accommodations to permit her to testify. The court gave her some accommodations. So, for example, she was able to have somebody take notes for her, sit with her at counsel table. She also was given a podium to stand at, which otherwise would not have been provided. And she was given the opportunity to have occasional recesses as she needed it. However, she asked for some additional help, which she did not get. She asked for a microphone so that she could project her voice in circumstances where that might be a problem. She asked for an interpreter to articulate her thoughts when she could not express them clearly herself, and also wanted a jury instruction explaining her disorder, lest the jurors think that she was just acting up. The lower court judge was very unsympathetic to her situation, saw her as delaying the proceedings, described her condition as simply one of stammering, which tended to minimize it, and she lost her case at the lower court level. The case went to federal court and ultimately to the Court of Appeals, and the court majority, through Judge Posner, said, look, this individual should have the opportunity to argue that these accommodations were needed in order for her testimony to be effective. There were some technical aspects of the case, but that was the essence of the conclusion. And in effect, one could view what she was asking for either as a request for reasonable accommodation or as an opportunity to allow her supporter, in this case her interpreter, to be with her and participate in the proceedings so that she could, in fact, bring the case that she intended to bring. And that really is all at the end of my part. Again, I'm happy to answer any questions at the end, so thank you for your attention.
All right, thank you so much, Bob. Just a quick note for everyone, we are still having technical issues on NCCJD's end, so you're only going to be able to hear me, you won't be able to see me, so I do apologize for that. And I'm going to now introduce our next kind of series of speakers. NCCJD was thrilled to partner with 4 law students to work on content for our competency white paper, and we are very excited to feature 3 of these hardworking law students now on our webinar. We want to give thanks to Wake Forest School of Law and Stanford School of Law for providing us with such great talent. Also, as a quick reminder to everyone listening, please go ahead and begin listing your questions for our speakers in either the chat or the Q&A boxes. You can go ahead and post them now. I will collect them, and then after we hear from the law students, we will start our question and answer session. So let me introduce you to Drew Flood. Drew Flood is a second-year law student at Stanford Law School. He has previously worked as a defense investigator at the Public Defender Service and the Louisiana Capital Assistance Center, and as a high school teacher in Chicago. Drew hopes to work as a public defender after graduating from law school and has a particular interest in how the criminal system understands and accounts for individuals with intellectual disabilities. He developed his paper on competency to stand trial and capital definitions of intellectual disability under the supervision of Professor Joan Petersilia at Stanford. So Drew, go ahead and unmute yourself and turn on your video, and you can get started.
Hi, everyone. Hope you can hear me. And thank you so much for having me. I'm really looking forward to presenting. So I'm going to jump right in. Basically, what my paper is about and what I'm going to be presenting on today is how definitions of intellectual disability that are used in the death penalty context or the capital context could maybe be imported into competency to stand trial proceedings. And just to give a broad overview of what we're talking about here, there are 2 main cases within the last 15 years that deal with the issue of intellectual disability and the death penalty. For full disclosure, I was an investigator at the Louisiana Capital Assistance Center, which handles death penalty cases, and that's how I first became exposed to this issue before coming to law school. So to understand Atkins and Hall, the Supreme Court initially, back in 1989, said that states could execute individuals with intellectual disabilities under the Constitution, and specifically under the 8th Amendment. But they came back in 2002 in Atkins and said that that was actually unconstitutional because it was cruel and unusual punishment, and that was mostly tied to the fact that individuals with intellectual disabilities are seen to have less culpability because of their inability to maybe understand both the planning stages of a crime and the actual commitment of the crime, and then afterwards understanding kind of the ramifications of a crime. So what the Supreme Court did in Atkins is they actually looked to the American Association of Intellectual and Developmental Disabilities, as well as the American Psychological Association, in order to account for how are we going to set up the measurement of intellectual disability. And they came up with 3 prongs. And these prongs now are following the DSM-5 after Hall v. Florida, which is a case I'll talk about in 1 second. So those 3 prongs were, first, the intellectual functioning prong, which says that you need to demonstrate significant sub-average intellectual functioning, and that's typically measured by IQ tests. So the WAIS, the Wechsler Adult Intelligence Scale, and the Stanford Binet are some of the most common that you tend to see in courtrooms in death penalty cases for determining whether or not the defendant has an intellectual disability. The second prong is that the defendant needs to show significant limitations in adaptive behavior. And adaptive behavior typically covers 3 domains, practical, conceptual, and social. And you look at a variety of factors. The Supreme Court actually hasn't been necessarily explicit on what those factors are, and that's something that I'll also talk about as this presentation moves forward. And then the third factor is that the age of onset has to be prior to the age of 18. So the defendant has to be able to demonstrate that before they were 18 years old, they showed these signs of intellectual functioning and adaptive behavior deficits. What Hall v. Florida talked about, if you can see the 3rd bullet point on this slide, is that that was in 2014. And essentially the court said the states cannot use rigid IQ cutoff scores. So states like Florida were saying that if a defendant scored above the IQ score of 70, they were automatically disqualified from being considered to have an intellectual disability, and thus they were eligible for the death penalty. And the court basically looked at that and said, if you account for standard errors of measurement on these IQ standardized tests, which basically say that a score that you get, so if I got a 75, my score could actually be anywhere between the range of 70 to 80. And so they said you can't have a rigid IQ cutoff score given that fact, and they struck down those types of statutes. What the court also did is they reinforced the fact that state standards need to be tied directly to clinical assessments. And so they said that states need to be looking to the DSM-5, they need to be looking to the AAIDD in order to really outline how a defendant can show that they have an intellectual disability, and thus that a defendant can show that they are not eligible for the death penalty. So before I talk about why these definitions should actually be imported into the competency to stand trial area, it's important to highlight a few problems here. First is that there are other forms of error on IQ tests other than the standard error of measurement, and one of them is the Flynn Effect. I'm not a statistician, so I always have a hard time describing this, and there's a lot of literature out there if you're very interested, and I'm happy to answer questions. But the basic upshot of it is that every year our population gets better at taking IQ tests. And so if you look at a test that was normed maybe 9 years ago, what the Flynn Effect says is that that number is actually over 3 years, the IQ scores go up about 1 full point. So if I took a test 9 years ago and I scored a 67 on that test, if that test was normed to today, my score would actually be a 64. And so what you see over time is you see inflation in people's scores on IQ tests, and that's important because if you're considering whether or not a defendant scored over 75 as not the cutoff, but an important line to draw under these statutes, then it matters what your score is and it matters how high or low it is. And that's where you see a lot of the debates in the death penalty area is over what is an IQ score. The second issue is that we just don't have a lot of guidance under the second prong, under adaptive behavior. And there's actually a case in front of the Supreme Court right now called Moore v. Texas. And if you're interested in it, I suggest that you look into it. It's currently in front of the Supreme Court and it'll be decided, I think, early next year. But basically what that is challenging is these factors in Texas, which I'll talk about in one moment as we talk more about the use of experts in these cases. So in terms of expert testimony, through Atkins and Hall, the Supreme Court hasn't given us any specific criteria for who can be an expert to testify to whether or not a defendant has an intellectual disability. And that's a problem in a number of ways. I'm going to highlight two main ones. One is these ethnicity-based upward adjustments, which Robert Sanger details in his article, and you can look into that, and I'm happy to send out a link. And that basically talks about that several experts are looking at research that says that African Americans and Latino defendants, or just individuals generally, score lower on IQ tests. And when they look at that, they're actually increasing their IQ scores when they measure that because of that general trend. And that's an issue because if you are in a state like Florida then, and you say that, well, if you score above 70, then we are going to consider you death penalty eligible, then those types of defendants who are African American or Latino or of a specific ethnicity are at a higher risk of being found eligible than other types of defendants. The other issue that we're seeing are experts in Texas in particular, and there was an expert named George Dankowski who kind of shows this broader ethnicity-based upward adjustments problem, who was looking at these types of defendants specifically from low-income communities and most often minority defendants, and he was saying they're not exposed to these types of practical skills that we look for under adaptive behavior specifically to show whether or not someone has an intellectual disability. So we are looking at, you know, can they take care of themselves? Can they cook for themselves? And he was saying they don't have those types of skills from those communities, so I think that they actually are probably less likely to have an intellectual disability. It's just that they don't have those skills. And the importance of that is just that those types of experts have been certified in the past. Dankowski was eventually eventually rejected from the forensic board in Texas, but they have been allowed to testify in the past. Dankowski testified in 25 cases, and overall, we just don't have enough guidance. The last area is these Briseno factors, which the Texas Court of Appeals has created, and literature basically says that these factors were created whole cloth. They don't follow scientific standards. The exact language is that it's substantive impairments in a person's ability to meet expected cultural and age-appropriate standards, which doesn't match up to the APA or the AAIDD, and is actually just really vague and difficult for defendants to prove that they have adaptive behavior deficits. So now that we've detailed some of the problems with the definitions of intellectual disability in the death penalty area, I'm actually going to tell you why I still think it's important that we bring it into competency to stand trial. So as Mr. Fleischner expertly detailed earlier, there's two main areas that we care about in competency to stand trial: sufficient presentability to consult with counsel, and also the ability to rationally understand the courtroom proceedings around you. And right now, the current doctrine of competency to stand trial doesn't actually account for intellectual disabilities specifically. And there's one other thing I want to highlight about competency to stand trial, which is that anyone in the courtroom, whether it's the defense attorney or the judge, specific actors, or the prosecutor actually, can bring up and challenge and raise into doubt whether or not a defendant is competent to stand trial. And for intellectual disability, there's actually two main issues. One is that individuals with intellectual disability frequently employ masking techniques, which means that they look like maybe they understand something or act like they understand something, but in reality, they actually don't. And so when we use these types of impressionistic standards where the judge is just deciding or has the power to determine whether or not someone actually has an intellectual disability or raise that into question, it's important that we're trying to flag this at an earlier stage rather than just kind of letting it slip through. The other thing, and as Mr. Fleischner talked about, is the inadequacy of restoration. I know that other panelists are going to go into this as well, but I'll just generally say that intellectual disability is it's not a curable or restorable condition in the way that maybe a mental illness is. So when you're talking about trying to restore back to competency, it's much more difficult and complicated. And there's actually some studies and literature that shows that maybe that encourages courts to find defendants competent to stand trial even when they might be incompetent, just because they aren't sure what they would do next. The other reason why competency to stand trial is important is that they already involve detailed inquiries into cognitive functioning. So at competency to stand trial, we're trying to really get in the defendant's head and understand how does this person's brain specifically work, and how are they able to communicate because of that, how are they able to understand the proceedings around them. And we already have this set of definitions in the capital context that isn't just kind of as loose as in competency to stand trial and is specifically tied to science for intellectual disability. And the last thing is just the efficiency standpoint. So competency to stand trial is in many ways a gateway to the trial at large. And if we're trying to not waste court resources in some ways, and if we're trying to make sure that we are not prejudicing these types of individuals who have intellectual disabilities to a trial that is in many ways unconstitutional, given what Mr. Fleischner said, then we want to understand this as early as possible and in the best way as possible. So a few different recommendations to kind of round out my presentation. One is that we need clear definitions of methods and practices for measuring intellectual disability, especially adaptive behavior. Standardized testing is one possible way of doing that. We've seen the problems with that under the first prong of intellectual functioning in the capital context, and we've seen kind of these errors that I talked about earlier. Under adaptive behavior, there is a current standardized test called the Diagnostic Adaptive Behavior Scale. But again, relying so much on standardized tests means that you expose yourself to error, and you also become even more reliant on experts, which sometimes can lead to more problems. So maybe a solution that I suggest in my paper would be for legislatures to outline, these are the types of documents, these are the types of testimonies that we require in looking into competency to stand trial and in looking into intellectual disability before we make a final determination. The other thing is increased accountability for experts. And whether that's legislature and state-specific created boards, whether that's courts determining that overall we are going to require this type of criteria from our experts who are testifying on intellectual disability in courts. There are a few different ways that could be gone about, but it is important when looking at across the country what types of experts are testifying to this, which is often forensic experts with no real background in intellectual disability, that this is an area that needs increased focus. And then the last thing is reforming competency to account for intellectual disability. And Mr. Fleischner, as I said before, went into this more, and I know it will be more from other panelists as well. But there are a few different litigation strategies that I would suggest, and this is going to get a little in the weeds with the law. But if we think about Atkins and Hall, they're talking about the idea that there is an evolving set of standards of decency in our society. And that's how they're deciding that even though before we said individuals with intellectual disabilities could be executed, now they can't be. So maybe that same type of logic can be applied to competency to stand trial. Even though before we didn't account for this specific type of cognitive condition, now we're going to, because we recognize that it's different than mental illness and it's important to distinguish between the two. The other thing is just the idea of due process. So we've already talked a little bit about how a defendant cannot be tried while incompetent to stand trial. So it's important then that we use the best mechanisms and measurements possible to determine what exactly is an individual's level of cognitive functioning and how are we assessing that and how is that impacting his competency. And then the third thing would be maybe understanding Atkins in a different way. So maybe Atkins isn't just saying that we're not going to execute individuals with intellectual disabilities. Maybe it also says that in areas of the law where we need to really closely interrogate psychological and cognitive conditions, so we really need to understand what's going on in someone's brain, then we need to rely on science, because judges and lawyers aren't scientists, and we need to understand this in the best and most accurate way possible. So those are just a few different suggestions. I'm happy to talk more about my paper and my presentation in the questions and comments section, and thank you so much for having me.
All right, thank you so much, Drew. Just a quick reminder to all of our listeners, please submit your questions through the chat box or the Q&A, and we will read those to our panelists at the very end. So just make sure you put your questions there, and we'll make sure we get some answers for you. Up next, we have Brooke Boutwell. Brooke Boutwell is currently a second-year law student at Wake Forest University School of Law. She graduated from the University of Tulsa with a degree in English Language and Literature. Her previous work includes victim advocacy through the Oklahoma City Police Department, as well as volunteer work with the Juvenile Diabetes Research Foundation, the American Cancer Society, and the Susan G. Komen Foundation. She worked on this project as part of her legal internship with NCCJD during the summer of 2016. So Brooke, go ahead and turn on your video and unmute yourself, and you can get started.
Okay, hi everyone. As was previously mentioned, I focused my paper on this nuanced issue that was brought up in Mr. Fleischner's presentation and in Andrew's presentation, which is the litigation that's surrounding these constitutional violations of people with intellectual and developmental disabilities in the criminal justice system. As was mentioned in Mr. Fleischner's presentation, people who are being found incompetent to stand trial or people whose issues of competency are being raised are being sent to state hospitals for, oh, there's my slides, are being sent to state hospitals for treatment. And because of the huge influx of the people that are being affected by this, a lot of these people, there's not enough room in these state hospitals. There aren't enough beds for any of the treatment facilities. And so these people are being sent to jail to wait for either their competency evaluations or their competency treatment. And these people have never been tried in a court of law. They have not been held guilty of offenses, but many of these people are spending weeks, months, and even years in jail. And as I talked about in my paper, some of these people are spending more time in jail waiting competency hearings than the maximum sentence that their offense would have carried. So this has been a huge issue in litigation as of recent years. I focused my paper on 4 specific state cases. I focused on 2 cases within Washington and Pennsylvania, where the case has already been tried and litigated and settled in 2 vastly different ways. And then I focused on a current case in Northern California that focused specifically on people with intellectual and developmental disabilities. And then lastly, I focused on an issue in Texas where some pending litigation is happening. So in Washington, the Disability Rights of Washington and the ACLU of Washington filed a class action lawsuit on behalf of individuals with both mental illness and intellectual and developmental disabilities who have been affected by this issue of competency wait times. The policy in the state of Washington already was that competency wait times should not exceed 7 days. This was being vastly exceeded. It ranged anywhere from over 14 days to over 56 average days that people were spending in jail waiting competency hearings. In this case, the judge found for disability rights in the ACLU, and the judge issued a permanent injunction against the Department of Social and Health Services in Washington, and they were forcing the services to comply with the 7-day minimum that they had set. They did not give any funds or any resources or any suggestions as to how the department should comply with the 7-day minimum. They simply said that lack of funds was not a defense and for this constitutional violation. A year later, that same judge began to hold the State Department in contempt because they were failing to comply with this 7-day minimum. At the time that the judge was holding them in contempt, only 20% of people had waited for the 7-day minimum in this case. So the judge began to issue fines of $500 to $1,000 for each person that was waiting for more than 7 days. On appeal, the Ninth Circuit held that the 7-day minimum needed to be reversed and that they needed to comply with a reasonable time limit for the competency wait time. In a very different way, Pennsylvania, the ACLU of Pennsylvania, filed a similar class action lawsuit on behalf of defendants with both mental illness and intellectual and developmental disabilities. But instead of being tried, this case actually went to settlement conferences. So the court approved a settlement for the ACLU of Pennsylvania that did not offer a specific minimum wait time, but instead gave very specific strategies as to how the Pennsylvania State Department was to fix these issues. So as you can see on my slide, they had a specific amount of treatment options that needed to be opened up within a specific amount of days. They went on to list what those specific treatment options could include and the amount of funds that needed to be allocated to different parts of those options. So those are two very different ways to look at the issue, and since they're so recent, we're still waiting to see how successful the Pennsylvania settlement will be. A very recent case that has just been filed in Northern California is extremely relevant to the issue that we're talking about today. This is the only class action so far that is focused specifically on people with intellectual and developmental disabilities and their families. People with intellectual and developmental disabilities face a really unique struggle in the jail population. There are two very specific instances that this case went into. One of the plaintiffs in this case was sent to wait in jail for over 8 months. He was put in the general population where he was subject to abuse by other inmates and rape, and he suffered some very serious psychological issues because of that. Another plaintiff in this case, in contrast, was put in solitary confinement, which happens a lot to people with IDD in the criminal justice system. And this particular plaintiff, his symptoms began to deteriorate, as many people who are put in solitary confinement for that long do, and he ended up committing suicide as a result. So the two plaintiffs in this case that I talked about in my paper, they look at some really serious issues that are specific to people with IDD when they're placed in these jail sentences for extended periods of time. This case in Northern California has just been filed. So far it survived all motions to dismiss and demurs that have been presented by the state. So we will see what happens in this case from here on out. And then the last state that I looked at was Texas. Texas was a really interesting case. In 2007, Disability Rights of Texas filed a class action lawsuit, and the judge found for Disability Rights Texas in this case, they said that they needed to comply with a 21-day minimum in this case. Following that order, Texas did a really good job. They added beds to the current state hospitals, they contracted out to private hospitals and other facilities, and they were able to get their wait time within the 21-day minimum. They were complying. Unfortunately, in 2014, an appellate court overruled the judge's decision in this case due to a legal technicality. And after that, all of the good work that Texas had done went out the window. Currently, their competency wait time is an average of 122 days, which is a huge issue. And the State Department has gone on record acknowledging what a huge issue it is and have said that they are working their best to try to develop strategies to get their competency wait time within a reasonable time. And they've also gone on record saying that they're currently just waiting for another class action lawsuit to occur to get them within competency wait time, which is reasonable. And that is all of my presentation.
All right, thank you so much, Brooke. Apologies that we lost some of the video there at the end. Again, some technical issues that came up. Now for our final presenter, Hillary Frame graduated from Vassar College with a degree in psychology and a minor in anthropology. She is currently a second-year law student at Wake Forest School of Law. She is the project coordinator for the Education Surrogacy Project at Wake Forest, which provides students in the foster care system with surrogate parents for their individualized education plan meetings. Prior to law school, Hillary was a case manager for individuals with disabilities who faced homelessness in New Orleans. She worked on this project as part of her legal internship with NCCJD during the summer of 2016. So Hillary, you can unmute yourself and turn on your video and get started.
I think it's working now. Okay, so hi, my name is Hillary Frame, and I'm really excited to be here today. So we are going to be talking about competency versus the insanity defense, and that is competency to stand trial, as a lot of other presenters have been talking about today. So first, we're going to talk a little bit about pop culture and competency and insanity. So anyone here who's probably watched Law & Order, CSI at some point in their lives has seen someone try to claim the insanity defense. It's something that's kind of thrown around in pop culture and in novels and things like that, without a lot of actual discussion of what it is and what it means to claim that defense. And kind of the difference between that and competency to stand trial, which often isn't ever discussed in pop culture. So a lot of people are really unaware of this. Due to the fact that the insanity defense is often depicted as the kind of way to go if you want to get out, not be held responsible for something, I think it's really important that people actually understand what it means, because I think that the kind of insensitivity around the insanity defense really shows where our culture needs to shift around issues with people that have intellectual and developmental disabilities, just simply because it's clearly, and at least as it's depicted, not a respected thing to do in a legal setting, when in actuality it's a very difficult defense and very different from competency to stand trial, which is far more common. So first, we're going to talk a little bit about competency to stand trial. Competency to stand trial is really a pause in the criminal case, which is where it really differs from insanity, the insanity defense. So basically, when there's a concern about competency, whether it's raised by an attorney or it's raised by the judge or someone else involved in the case, the criminal case is put on hold, and then this person goes into waiting to be evaluated for competency. So that's kind of where Brooke's presentation comes in, of people sitting in jails waiting to be evaluated. When things are going correctly, though, or in a timely manner, the timeline is very structured. So the person will wait for their bed to basically open up in a psychiatric hospital often, sometimes a forensic hospital, just depends. And they will then go and be tested or evaluated for their competency. The test, the CAST-MR, is what is often used to review competency to stand trial. And basically what will happen is the person might take that test, they'll be evaluated by a psychiatrist or psychologist who will talk to them, ask them different questions about what they understand, if they understand basically their rights as a defendant, things like that. And then the psychiatrist or psychologist will put together a report, which will go back to the judge. The judge has the final say in whether they think the defendant is competent to stand trial or not, despite what that report might say. So that report might say, we would recommend this person be found incompetent to stand trial, or the opposite, and the judge, can say, I disagree with this, and the trial might proceed, or the person might be found incompetent to stand trial. If the person is found incompetent to stand trial, they will go for restoration of competency, which also, as was covered earlier, can take place in various locations, often in a psychiatric hospital, or and that can take quite a long time depending on what's going on. And if someone is found to never be restored to competency, they can be held for various lengths of time depending on the state you're in. Sometimes that might even be longer than how long they would have been held if they had just been tried and found guilty and sent to jail, or sent to prison rather. So it can be really troubling to see how long people can be waiting to be restored to competency. So moving forward a little bit, because we're going to come back and revisit this in the in how it applies to people with IDD after we discuss insanity here. So the insanity defense is what it is. It's a defense. So that means that at the time of the crime, the person could not be held responsible for their actions. Whereas incompetency to stand trial has nothing to do with the crime itself. It simply has to do with at the time of the trial. So the insanity defense claims that the person should not be held responsible for a crime. There are different standards for this defense that I'm going to talk about here in just a second. There are a few different ones, but we're going to talk about the main four. And what I really want to stress is how rare this defense is. As you can see in the quote that I used on here on the slide, it's only used in less than 1% of cases, and when it is used, it's clearly not the most successful defense in the world. 64% of people are still found guilty, with only 1 out of 4 people of this very tiny number being found not guilty by reason of insanity. So it's very much not a kind of get out of jail free card, if we want to be kind of cavalier about this, because it's very much a serious thing that people use and involves some very serious mental illnesses or other issues going on in a person's life. And we're going to talk a little bit about what that means here after we discuss these standards. So these are the 4 most common standards for insanity. They can vary by state to state, but you have the, I'm probably going to say this wrong, the Intern rule, which basically states that a person at the time of the crime did not know the nature of it, they didn't understand what they were doing was wrong, or they didn't understand that they were hurting someone, something like that. The irresistible impulse rule is that at the time of the crime, the person had such an impulse to act in a way that they couldn't tell the difference between right and wrong, and so shouldn't be held responsible because they were unable to stop themselves. The Durham rule is that basically someone isn't responsible for a crime if the act is a product of something that's going, mental illness or other kind of disability that's related to the mind. And then finally, we have the American Law Institute Model Penal Code, which talks about substantial capacity to appreciate the crime. So basically stating, again, that they didn't understand the significance of what they were doing, or didn't understand or weren't able to conform to what the requirements are of the law. So as you can tell, there are a lot of similarities and overlaps between these 4 different rules, but they all do kind of vary a little bit and have different impacts based on their subtle differences. So kind of moving on to how this affects people with intellectual and developmental disabilities. The first thing I wanted to discuss is that it takes longer to restore someone to competency, that if they have an intellectual or developmental disability, which makes this more problematic in the sense that most people don't know about restoration of competency. So when you add that on to the fact that it's going to take them longer to be restored to competency, it kind of snowballs into a larger issue. Another kind of misconception that I want to talk about is that a diagnosis of intellectual or developmental disabilities does not automatically qualify someone as insane or incompetent to stand trial. The same goes for a mental illness. Neither of these things automatically mean that you can't understand your actions or you weren't responsible for your actions. So it's of the utmost importance that we look at the individual person and not a stereotype someone is holding about a mental illness or someone with IDD, because these are fully formed individuals who are all different and have different abilities and different ways of going about their lives, and so just because they have one of these diagnoses doesn't mean that they're automatically going to qualify for something, for either the insanity defense or an incompetency to stand trial. It's also just for everyone's clarification, it is far more common to raise an incompetency concern than to use the insanity defense. People that have intellectual or developmental disabilities, I believe, as we discussed earlier, are roughly around 10% of the use of incompetency to stand trial. So it's far more common to go that route if someone is concerned about a person's understanding the trial or something to that effect. That's basically what I have for today, but I just really want to stress the fact that you really need to be looking at individuals, and the kind of indications around our culture with this is that, you know, we don't really take this seriously in our media and things like that. So it's of the utmost importance that there be a cultural shift around this to where it's clearly shown as a very serious thing to engage the insanity defense, and also for there to be more awareness of the incompetency to stand trial, simply because this is something that affects a lot of people and it's just not that well known. But thank you so much for having me today, and I'm happy to answer any questions.
All right, thank you so much, Hillary, and a big thank you to all of our presenters. I'm going to start reading questions from the Q&A and chat boxes in just a moment, so be ready with your question if you haven't already sent it to us. Also, if your question isn't answered during this webinar, or if you find you have other questions later, you can always send those to nccjdinfo@thearc.org, and that address there is on the screen. Also, as a reminder, after the webinar, we will have a short survey for you to fill out. This survey really helps us provide quality webinars to our audiences, so please do take a moment to fill that out at the end of the webinar. And one more quick announcement, we would love if you could register for our next webinar, The Intersection of Race, Disability, and Policing, which is scheduled for January 19th, 2017, currently at 1 p.m. This exciting webinar will be the first in our series on policing people with disabilities, and the link to register is also there on the screen. Okay, so turning to questions. So what will happen is presenters, I will read a question from our audience, and then whoever would like to answer the question, you can just unmute yourself and give your answer. We're not going to use video during the question and answer session because it gets a little too dicey, but just unmute yourself if you would like to answer a particular question. Okay, so turning to our first question. What is the difference between guardianship and power of attorney? So probably one of the attorneys, if you could let us know the difference between guardianship and power of attorney.
Hi, this is Claudia Center. I'm not an expert on this, but I can answer the question. The difference is that guardianship is a finding by a state court, usually the probate court, that an individual because of their disability is unable to take care of themselves, their basic needs, like their clothing. Power of attorney is a document that an individual who has capacity to enter a contract enters into with another person. And then in the future, if the person becomes unable to make decisions that are covered by the agreement, the person who holds the power of attorney then steps into the shoes of the individual.
Hi, this is Bob Fleischner. Let me add to what Claudia said. There are two other kinds of powers of attorney. One is a power of attorney that is effective immediately, is not dependent on future incapacity. So if I were if I were leaving to go out and to walk the Appalachian Trail and was going to be out of communication for the months that it took me to do that, and I wanted someone to be able to handle my financial and other affairs while I was gone, I could give someone power of attorney to do that. Another subtype of power of attorney is a common one of power of attorney for health care. It's often called the Health Care Advance Directive, and that usually is one that comes into effect on a person's incapacity and is, in most states, is a separate kind of a document that gives an agent the authority to make health care decisions. These are very nice alternatives to guardianship.
All right, thank you, Claudia and Bob. Our next question, can a guardian for legal proceedings where a defendant has been determined incompetent be a time-limited guardianship? I can read that one more time. Can a guardian for legal proceedings where a defendant has been determined incompetent be a time-limited guardianship?
So this is Bob Dinerstein. If I understand the question, what you may be asking about is something called a guardian ad litem, and that's a guardian who is appointed for the purpose of litigation or hearing in the litigation. But to be clear, you wouldn't be able to, for example, make the defendant competent because you appointed a guardian to become competent for him. There are certain aspects where you can't, basically can't delegate that, and so that would be, I think, the issue here.
Yeah, this is Bob Fleischner. There's a really interesting case in Massachusetts in which a defendant with an intellectual disability was charged with a fairly serious crime, and had a guardian. And the defense and the guardian had agreed to a really remarkable plea bargain in the case, which would have prevented institutionalization of the person for restoration. And the judge refused to accept the guardian's acceptance of the plea, and the state Supreme Court, consistent with what Bob's just said, said that that's not something guardians can do.
Okay, thank you. Our next question, could one of the panel members discuss the distinction between restoration versus attainment of competency for individuals with intellectual or developmental disabilities? So restoration versus attainment of competency for people with IDD.
Well, this is Bob Dinerstein again. So restoration simply means that if you have had your capacity questioned and a guardian appointed for you, the restoration would be to be able to receive, or once again, to be able to exercise your decision-making rights. But I think it's important to understand that no matter what condition a person is deemed to have, whether it's IDD or something else, you have inherently capacity and you are competent until you're determined otherwise. And I think, as several of us have been saying on the call today, that even if you think it's really clear that someone doesn't have it, competency or capacity, many determinations in court proceedings are very explicit as saying these are not meant to be general determinations of lack of competency. So restoration only comes into play once there has been a court proceeding to take your capacity away or to say that you don't have it. But the state of nature, if you will, otherwise is that you have capacity and you are competent.
All right, thank you. Our next question actually came from multiple members of our audience. Why is the cutoff age 18 for people with developmental disabilities instead of 22?
I can start answering this question. I'm sure one of the attorneys can explain more, but my understanding, I don't know if why is necessarily the best way to go about it. I know that basically up until recently, I believe it's the AAIDD, although I may be wrong, has changed it to 22. I know that also among the literature that there is a call for the legal standard to be changed to 22 as well. And one of the main reasons for that is because prior to the age of 18, especially in low-income communities, there's a concern that individuals may not come into contact with the types of structures or resources that would maybe have the types of records that would show that they have an intellectual disability. Whereas 22, it's believed is like a more accurate time scale to have. Generally, like the timeline issue is something that's it's been pretty established as 18 for a long time. I think in the psychological community has recently moved more to 22, but within the court system, they haven't necessarily made that move at all, and that includes going back to Hall, which even based on the DSM-5 was still saying 18.
All right, thank you. Another thing to go with that question is that, the Supreme Court has said that the age of majority in the United States is 18, but states can always be more protective and increase that age. So that's another place where sometimes that distinction can come from. Okay, we have a comment here. I'll read it, and then if one of the panelists would like to respond, please feel free to do so. The comment says, "It is interesting that individuals with developmental disabilities who are victims of a crime are not considered credible witnesses to testify, and therefore many times the case never goes to court. But yet when they may be the perpetrator in the case goes forward." So if anyone wanted to comment on that, please feel free to do so.
Yeah, this is Bob Fleischner. I think Bob Dinerstein talked about this some in his presentation, and I think the comment's right. It is often, if you read the cases on competency day trial for people with intellectual disabilities, it's sometimes remarkable how courts come to the conclusion that the person really understands what's going on. And some of that may be because of the masking and the other things that the other presenters have talked about. But there are an increasing number of cases, small but increasing, about accommodations to witnesses and victims to allow them to testify. There's a very good Massachusetts, sorry, I keep coming back to Massachusetts, but there's a very good Massachusetts case within the last couple of years of a woman who was sexually abused in a nursing home. Her disability was that she had aphasia, so she couldn't form words. The judge, in that she was able to communicate enough with the nursing home staff and with the police to explain that she was, and the prosecutor for that matter, to explain that she'd been sexually abused and to identify the abuser. But the judge found that she was incompetent to testify because she couldn't speak. And the Massachusetts State Supreme Court, using a state law, state anti-discrimination law, found that she should have been accommodated. Case went back to trial. She was provided with an interpreter, and she testified about the assault. So I think that there may be some increasing movement in the right direction on this, but I agree overall with the comment.
This is Bob Dinerstein. I would just add to that. Part of the question is who's making the judgment. So when it comes to witnesses or victims, it's often a judgment by a prosecutor who may believe that the case is hard to prove if the testimony of the victim is critical to it. And that can be a problem with the prosecutor's understanding of disability and how those steps that might be taken to enhance the credibility of the person with a disability, including activating whatever supports the person might have. The second piece of that is that sometimes the prosecutor, in order to make a better case, will want to portray the person with an intellectual disability as a very vulnerable person, as somebody who has no capacity at all and therefore was taken advantage of. And that can lead to a tension between the person's own sense of identity and where, for example, even if they had capacity, if they didn't exercise it in this case, say to consent, they shouldn't, they are victimized by the defendant. From the defendant's standpoint, I think there are all kinds of ways in which the system can be difficult for defendants, not the least of which is, in addition to everything else that's been talked about, the tendency of defendants with intellectual disabilities to give statements and even confessions that are not really necessarily accurate, but which they believe they should be giving as a desire to please the person seeking them. So there's definitely some huge barriers here, which I think seminars like this, I hope, will be part of the way toward addressing those.
All right, thank you for those for that discussion. Our next question. There is a tool used to look at reliability of witnesses that has been used with people with IDD despite not having been tested with them. Is there any work on creating an evaluative tool for competency for people with IDD? So the question is about an evaluative tool for competency specifically for people with IDD. Okay, I'm hearing no responders to that question. So
I can say one thing.
Okay, perfect.
Really I know that and I think it was referenced in one of the other presentations, but the CAST-MR is, I mean, one of the issues obviously that's been talked about in this webinar is the need for a distinction between mental illness and intellectual disability in the competency realm. And the CAST-MR is one test that I understand that experts use that's specifically designed to assess competency for individuals with intellectual disability. That being said, I think that there's definitely legitimate criticisms to be had of that, especially when you're considering how does restoration interact with intellectual disability, and can someone with an intellectual disability actually be restored to competency? And so, that tool is obviously affected by that eventual consideration too. But that's one thing that gets used. There's other tests that I've seen that are getting at specifically, do you understand what are the different roles in the courtroom? So do you know what the prosecutor does? Do you know what the judge does? Do you know what your attorney is supposed to do? But in some places, like I've studied it specifically in Georgia, it can really be just like a list of factors, and experts can kind of go about it in whatever way they choose in making their determinations, and they're given a lot of flexibility.
And this is Bob Dinerstein again. I would just add to that it actually is a huge gap. There have been efforts, I think, to try to adapt some of the tests that have been used with people with mental illness or psychosocial disabilities. The sort of MacArthur set of criteria with regard to capacity and determinations. And one of the issues is there's dispute about the criteria that MacArthur uses, and one of the ones that would be of particular relevance here is a requirement of appreciation. That is, does the person really appreciate the nature of the choice that he or she's being asked to make? And depending, again, on whether you're talking about eligibility for the death penalty or competency to stand trial, you may move in different directions about that. But that understanding of that interpretation or inclusion of appreciation can be very create a lot of conflict, because that's a very socially contextual judgment to make.
This is Bob Fleischner. One of the things that I've thought have long thought that all of these tests, regardless of what the disability of the individual is, totally misses is and doesn't test is the lack of a better word, the competency of the lawyer. One of the key factors in these considerations is whether the person can communicate with their attorney and assist in their defense. And it seems to me that a substantial limitation on that is whether the attorney is able to communicate with a person with a disability using the kinds of tools that Claudia talked about and the kinds of approaches that Claudia talked about. And sometimes in court, I've seen judges, or actually been asked by judges, can you talk to your client? Do you think you can get, you and your client can work out a defense? And if I say yes to that, the judge gives a lot of weight to that. But that's not part of the testing that the professionals the clinical professionals are doing in the facilities. And I think it misses a huge part of what competency stand trial is all about. Too many lawyers are too willing, unfortunately, to have their clients found incompetent to stand trial, thinking that that's better than a sentence, when in fact, as has been pointed out earlier, person may actually spend more time at a facility than they would ever spend in a prison or jail, which they might never spend any time in a prison or jail if they would go to trial.
Yeah, I think those are some very good points. Kind of a related question, but on the flip side, what is the experience of any of the presenters regarding programs or curriculum for training persons with IDD to actually gain competency? So not to evaluate it, but to actually restore competency.
This is Bob Dinerstein again. This is a great question because I think really there's a lot of mystery around the concept. And one of the things I think that people increasingly are focusing on is making this a part of the issue of transition for those students who are receiving special education and making the transition out of K through 12 into post-school education or work. That for many people with IDD, the problem has been they've not had a lot of practice in making decisions, in making mistakes and learning from them, and therefore having opportunities to express their capacity. So even though intellectual disability itself is not a condition from which you can recover, you certainly can learn additional skills and be trained in it. That requires, I think, a much earlier focus than we traditionally have given, and also a focus on autonomy and self-determination and ways to build up people's understanding of the world around them. But I would add to that again, or reiterate, if we think about how typical people learn, they learn because of information they receive, but they also learn by experience and by getting feedback on that experience, including sometimes having fallen on their face and then getting up again. And we have to provide opportunities for people to have those experiences and learn from them.
I don't have any independent way to assess this, but several people who write about restoration or achievement of competency for people who are with intellectual and developmental disabilities or for incompetent stand trial cite to a method that's used at the Ellen S. Slater Hospital in Rhode Island that's generally known as the Slater method. And that's apparently a fairly comprehensive educational program that's used in Rhode Island, and it is mentioned any number of times with in very supportive terms in the literature. So, I don't know. I have no independent way to judge that, except some experts seem to like it.
Okay, thank you. We'll go on to our next question. Could the panelists address the issue of how a determination of competency relates to the right to legal capacity, or a person's right to be recognized as a person before the law? So competency versus capacity versus a right to be recognized as a person before the law.
Well, I'll take a stab at it. Again, I think going back to one of the very first slides we had for the session today, capacity is the broader concept, and competency is a very specific and a kind of on-off switch as to whether you can go forward in the context we've been looking at, whether you can go forward with court proceedings. The issue of capacity that the question is alluding to, I think, requires us to make a distinction between legal capacity and mental capacity. So legal capacity is just something you inherently have as a human being. You can't lose it. It's what Article 12 of the CRPD recognizes and says, for example, that you always need to be in a situation where directly or indirectly you can bring to the attention of authorities one way or the other that there's a legal matter that you have an interest in. In some countries, having your legal capacity taken away means that you can't even, for example, challenge what your guardian is doing because you're thought not to be a person before the law. So that's a problem. But we do know that people have conditions, and some of which we've been talking about today, and there are additional ones like dementia and traumatic brain injury, where the person's actual mental capacity at the time we're measuring it is in question. And there, going back to what we talked about earlier, they may be able to be supported in their expression of legal capacity by somebody or some people who form a network with them and can speak for them if necessary, or permit them to speak for themselves with assistance. And the goal in all those cases is to try to identify the underlying will and preference of the individual. If that can be done, then that person has legal capacity, even if it's expressed in unusual or indirect kinds of ways. Whether that would be applicable to somebody who's in a coma and is not able to currently guide his or her network is something which commentators and theorists debate. And one of the issues is whether it's appropriate to think of a person as not just an individual, but as sort of surrounded by his or her network. But for the most part, even if we don't get to those kinds of cases, we're really saying that we start with a presumption, and not only a presumption, with the unchallengeable presumption that everybody has capacity, and the expression of mental capacity is going to depend on some of the things we've been talking about today.
All right, thank you so much. Our next question, who is responsible for covering the cost of the restoration testing when that issue is brought up? So who pays the cost of restoration of competency testing?
So this is Ashley at NCCJD. I can answer this question. Generally, it depends. If it's an indigent defendant, usually the state will pay. There's usually a statutory scheme for the cost, but oftentimes it's part of the cost that goes to the state. It's not generally like the prison system, for instance, where inmates are charged for their residence. But again, it's very state dependent, and it depends on which jurisdiction you're in.
All right, thank you, Ashley. Okay, our next question, what does it mean when an individual with IDD vacillates between competency and incompetency to stand trial for charges, and how often can this be evaluated? So going back and forth between competency and incompetency to stand trial, and how is this evaluated?
I think the answer, this is Bob Fleischner, I think the answer to that is that where an individual's capacity vacillates, the question is, the timing is the time of the important event. So that's either trial, or whether the person has capacity at the time of trial and to sit through the trial and to participate in the trial, or if the settlement discussions are trying to find a way to plead out the case when those plea agreements are entered. Competency to stand trial is a question that can be raised at any time by any of the parties to the case, by the judge or by the prosecutor or by the defense lawyer. At any time, any of the participants in the case think that the person does not have capacity or does not have is not competent to stand trial, that issue can be raised, and so it has to be evaluated at that time. So it's not uncommon to have someone found competent to stand trial at the beginning of the case, and then at some point in the case have that question raised, even during trial, based on the person's behavior during the trial, and have things stopped again, a pause in the trial to have that evaluated. That's more common, I think, with people with mental illness, but it certainly could happen with anyone. With people with mental illness, there are really interesting constitutional questions which go beyond what we can talk about here, is whether the state can force a defendant to become competent by forcing them to take medication that they don't want to take, or whether a person can be forced to appear before a jury in an incompetent state if they claim that they were, for example, not not guilty by reason of mental illness at the time they committed the crime. But those go way beyond. They're tough questions that we leave to law professors mostly, and they go beyond what we're talking about here. But the question about vacillating competency is a good one.
Okay, hearing no other panelists on that one. Our next question, intellectual and developmental disabilities cut across witnesses, victims, and defendant classifications. Are supported decision-making methods and guardian ad litem appointments the best choices for accommodation, and are these the only methods?
This is Bob Dinerstein. It's certainly not the only method, and I think as I tried to convey in my portion of the presentation, there's a way in which reasonable accommodation looks an awful lot like supported decision-making. In some ways, it has to do with how the person comes to the proceedings in question, so that if somebody is in a supported decision-making arrangement, has a document which reflects it, which the person uses, and you are coming into contact with that person as an attorney for the person, as a prosecutor using that person as a witness, that will be a group of people with whom you will need to figure out how to interact. Again, Claudia's presentation, I think, addressed some of those issues. The tendency has been historically for lawyers and others to want to work through the surrogate or the guardian and not the individual. And I think the push in supported decision-making and in Rule 1.14 is, in fact, to say, look, you still have to use the individual as the primary person with whom you interact. In the same way that we would say that if somebody with a disability in another context had an aide, we wouldn't be doing our work through the aide, we were doing our work through the individual, him or herself. So I do think supported decision-making is not a panacea. There are some of the risks with guardianship could apply to supported decision-making. What I think it does do is it provides a context for people who know the individual well and therefore may have a better opportunity to really help that person express his or her will or preferences.
All right, thank you. Our next question. Is it a conflict of interest for an individual with IDD to be restored to competency in a facility operated by the state?
Well, I don't think so. The Supreme Court has said that the state has strong interests in bringing people to trial in a speedy way. So there is a state interest in that, and the individual has an interest in having a speedy trial and having the criminal charges determined. So those interests are usually concurrent, and I think that that there probably is no, we may imagine a conflict, and there are places where it can conflict, places where there are good problems, like the defendant talking about the alleged crime with people who don't carry a privilege and those sorts of things. But I don't think inherently this, in my opinion, this is not an inherent conflict.
Did any of the other panelists want to comment on that?
I would just add it's Bob Dinerstein. I think I agree with Bob. The situation, which I think is a clear conflict and has not been resolved, although Bob alluded to it earlier, if you have a defendant on death row who has mental illness, since a defendant with intellectual disability shouldn't be there, but if the person has mental illness and is not competent at this moment, he cannot be executed under the case law. But there is an open question as to whether he can be forcibly medicated to make him competent and then eligible for execution. It's hard to see in that instance that it's in the defendant's interest to become competent, and it obviously is in the state's interest to make him so. But so far, at least no definitive ruling from the Supreme Court about that.
Okay, thank you. Our next question, how does restoration of competence to stand trial assist the individual with obtaining services and supports they may need? So can and how does restoration of competence help the individual obtain services and supports?
Well, it's really kind of apples and oranges, because the need for and eligibility for supports is really independent of a determination of competency. I guess you could say the way in which that would be true is if by becoming competent, the defendant can be tried or can enter a plea, and as a result of that, be eligible to receive certain services through the criminal justice system. But my concern with those kind of arrangements is that often that leads to a kind of ongoing involvement in the criminal justice system that may not be in the defendant's interest, actually. And I agree with Bob when he said earlier that you really have to sometimes be critical of the lawyers here, who sometimes want to do anything to avoid the criminal justice system without really looking into what the alternative is. But another thing you find sometimes is lawyers who, as long as they can reduce the amount of incarcerated jail time, which is certainly often a goal, agree to a series of connections and requirements that the person fulfills, say, as a matter of probation, which can be only setting or can set up the defendant for failure and revocation of probation and the like. So my view is to be careful about the use of the criminal justice system as a way to get supports, but to separate out those two goals. Getting supports is one thing, being competent to stand trial is another.
Okay, thank you. It looks like we have time for just maybe one more question for our panelists. So we'll end on this question. And if we did not get to your question during the webinar today, you can still send your question to nccjdinfo@thearc.org. And that's the address there is in the Q&A chat boxes. So if we did not get to your question, you can always follow up with us and we will answer it. So our last question for the panelists: when a defendant is under guardianship, what impact does that have on a court's determination of competency? Do they even take this into consideration?
I think the answer is yes, they take it into consideration, but it's not determinative. Because as several of the speakers have said, and Claudia said it, and others, that the determination of guardianship, consideration of incapacity for guardianship, is really a very different determination than competent to stand trial. Person could be incapacitated for some reasons and under guardianship, but perfectly able to understand what's going on in court.
Any final thoughts from our panelists? Okay, hearing none. If you are further interested in the topic of competency, the ARC's NCCJD will be releasing a white paper on the topic that our panelists have all been authors of later, well, before the end of this year, hopefully sometime soon. So definitely keep an eye out for that. Remember, you can also send any questions or follow-up thoughts you have to nccjdinfo@thearc.org. But other than that, we just want to say thank you once again to all of our panelists, and a big thank you to all of our audience members who are here with us today. So thank you so much. All right, goodbye, everybody.